Good evening. Can I please welcome everyone to this meeting of the Licensing and Regulation Committee on Tuesday, the 5th of September, from the Walton Suite, Winchester Guildhall. The time is 6:30. My name is Councillor Brian Laming, Chairperson of the committee. This meeting is being live streamed on the Council's YouTube channel, and the recording will also be available after the meeting. Subtitles can be switched on, and advice on how to turn these on is set out on their website. Can I remind members the use of their microphones? Can everybody be ensure their mobile phones are on silent? In the unlikely event that it is necessary to evacuate the building, the fire alarm will sound. Please follow the instructions given to you by our team. Turning to the agenda. Apologies for absence.
Thanks, Chair. Yes, we've had apologies from Councillor Kern, for whom Councillor Cunningham is deputising, and Councillor Eve, for whom Councillor Morris is deputising.
Thank you. Now we come to the appointment of Vice Chairman for the year 2023 to 24. Can I ask for nominations, please?
Chair, can I nominate Councillor Brophy?
Thank you. Do we have a second? Thank you. Any other nominations? Right, would you like to come up and take chair, please? Disclosures of interest. Do we have any today? No. Minutes of the previous meeting held on the 7th of December. I ask if they agreed as a true record. Thank you. Public participation, there's nobody registered today. So we come on to the first item on page 9, which is the statement of licensing policy under the Licensing Act 2003.
Thank you, Chair. This report is to review the licensing policy under the Licensing Act 2003 prior to consultation. The policy must be reviewed and adopted by the 6th of February 2024. The changes proposed are listed on pages 13 and 14 of the report pack and are track changed in Appendix 1. In summary, the main changes proposed are pages 10 and 11, reference to the Live Music Act 2012 and the Deregulation Act 2015, and the expectation on premises licence holder not to create unacceptable nuisance where the activity is exempt. Page 24, to include consideration by applicants relating to procedures on how to deal with reports of violence against women and girls, which is being highlighted by the Hampshire Police and the Police and Crime Commissioner. Page 26, recognising that the Regulatory Reform Fire Safety Order 2005 replaces previous fire safety legislation. And a reminder that the licensing authority will not seek to impose fire safety conditions on a licence or certificate where the order or any future fire safety guidance or legislation applies. Conditions should not duplicate any other legislation. Page 26, to expect applicants to consider national safety campaigns and measures on how to deal with drink spiking and how to deal with any reported incidents of these. Also on page 27, we've added a reference to counter-terrorism considerations in line with the updated Home Office guidance issued under the section 182 of the Licensing Act 2003. And pages 27 and 40 to 47, we've removed references to additional matters which should be considered by applicants, which were outdated conditions used prior to the Licensing Act 2003. Chair, I just wanted to highlight on page 44 of the report, under the Appendix 1, under counter-terrorism, the additional 2 paragraphs have been incorrectly numbered, and they should follow the previous numbering and be at B4 and B5. Not reset at B1 and B2. Before the policy is adopted, we must consult relevant parties, of which they are listed on page 14 of the report. And we would also add a public notice onto the council's website. The recommendation for members today is to review the draft licensing report at Appendix 1, including any further amendments by the committee today, and they be approved for consultation as detailed in paragraphs 10.6 to 10.9 of the report. Thank you.
Thank you, Carol. Right, members, shall we go through this in blocks of pages or just individual pages? Any preference? Okay, we'll do page by page then. Page 19. Have we got any questions? 20, 21? 22, 23, 24? Although, sorry, I did forget one thing. This is a recommendation that the reviewed draft licensing policy Appendix 1 includes any further amendments and by the Licensing Regulation Committee to be approved for consultation as detailed in paragraphs 10.6 to 10.9 of the report. My apologies for that. We go on page 27, 28, 29. 30, 31, 32, 33. Hang on, page 39. Right. Yeah,
Thank you, Chair. Page 34.
sorry.
Page 34.
Yeah.
There's an amendment at 315 to say, crossed out he, she, it says they, and the line underneath that still says his, her. I think that should be crossed out and have their.
Yeah.
Yes, good spot. Thank you very much. With permission from the members, we'll amend that ready for consultation.
Yeah. All right, up to page 39. Any questions? 40, 41, 42, 43. Yes, Councillor Pearson. That microphone, please.
Sorry, paragraph 8, I'm looking at page 41. I may be a bit pernickety about this one. I've got no objection to it as written, but as a question arises from it, we see how to deal with reports of violence against women and girls. Right, okay. Does that imply attacks against men and boys is okay?
Absolutely not, Councillor. The reason for specifying this particular violence against women and girls is something that's been highlighted in particular by Hampshire Police and the Police and Crime Commissioner as a operation, I guess, as the police would call it, in terms of tackling this particular offence, which is on the increase or certainly reported increase. So absolutely not does it mean that it's acceptable to do that to males. It's just referring to a particular police campaign that we're aware of. But if you'd like to add something in additionally,
We
can
quote
do.
a number of places in the papers the Equalities Act. Have you seen the recent this week's ruling by the Equalities Board about schools identifying specifically groups like this? And does that affect us in any way?
Sorry, can you repeat that for me, please?
The schools have been pointed out by under the Equalities Act that by specifically separating out a group of people in a school, which presumably is in a population, it's against actually the Equalities Act because you are talking about one group and not all of the groups. Now, the query basically is, I mean, I understand exactly the reason for it. I'm not arguing that. What I really want you to define is, in the light of that ruling, it's only this week, is this statement still correct for us? I can understand why the police are saying it, and I would defend it along with all of you. So I'm rather old-fashioned in that sense, but simply I'm looking at what was reported in the Times, what they said about schools, identifying specific groups within schools. Now, does that ruling affect us in this situation?
Chair, perhaps I could help on that point, and Carol. I mean, what I would say is that attached to this is a full equality impact assessment, where equalities have been fully assessed in accordance with the legislation, and it certainly would be open to us to review that in the light of recent case law. But you know, an equality impact assessment is something we should keep up to date anyway. And I think that would be the right place to look at those issues. So we can certainly look at it again before this comes back to you.
I can just add, I think ultimately this review in an ideal world will be for the 5-year period. We can review it earlier than that, but what we've tried to do is look at the policy, and an example is the temporary event notices. We've removed the numbers because that has changed by government. What we don't want to do is for it to specify a number if that might change. So if members feel that actually we need to preempt the way in how we work or any changes that may come up in the future, and would prefer not to reference a particular campaign like this, and we look to have a more generic wording about how we want premises, licence holders and applicants to consider all types of I mean, we've referred to it already about a different. Yeah, we want to cover everyone. This is
This article and send it to you, and perhaps we can come back at a future time and have a look at it again if necessary. Is that a fair comment to both of you?
I think it is, yeah, but ultimately, as I say, if
Yeah.
we can try and make this as future-proof as possible for the 5-year period, if members do have concerns about that
Yeah.
particular statement within the policy and wish to remove it or reword it, then I'm open to discussion tonight. That's no problem.
Yeah. Well, I will do that for you, and then you can make a judgment in the light of this. Whether the licensing is different from what is happening in schools, I know not. I'm simply saying that is a ruling that was made during the course of this last week. Okay.
Okay. We come back to page 43 with the renumbering that you put in on that. Any queries? 44 and 45.
Yeah, query.
Yeah.
I'm noting that these changes are being made in accordance with the 2003 Licensing Act. And I'm just wondering why it's taken 20 years for it to be implemented. Is the Licensing Act changed in the meantime and updating it because the Act itself has been updated?
Sorry, can I just clarify what section you're referring to be updated? You're referring to the fire safety order?
It's the Guiding Counter-Terrorism start from then on.
The counter-terrorism, the paragraphs that have been added are from the very recent changes to the Section 182 guidance under the Licensing Act. So counter-terrorism, as we all know, has not just been something that's happened in the last couple of months. What has changed is that it's been specifically referenced in the Section 182 guidance under the Licensing Act. So in line with that, we thought it was useful as part of this review to make reference to the changes, and the fact that the government have felt the need to put it in as part of the guidance for members of the public, applicants and members when making their decisions. We're reviewing the policy. It's a good time to make our own reference in our own policy about expectations or what members might require in future. So this is not new. We know this has been going on a long time. What is new is the guidance that was issued in August from the government, which included counter-terrorism.
Thank you.
Yeah. Moving on to page 46 and 47. 48, 49. 50, 51. Then come on to Appendix A. We haven't got any questions on pages 52, 53. Right.
Thank you, Chair. Could I just ask, I don't have any problem with this as a statement about policy, given that a lot of the changes, as you've just said, were brought about by changes in central government guidance. this sits as a piece of high level policy for Winchester. Do we have any further local guidance on how, as a committee, we should assess an application with reference to these various new criteria, such as violence against women or anti-terrorism aspects, or do we simply use the central government guidance?
Both. The policy, so the section 182 guidance is issued nationally by the Home Office for members of the public, licensing authorities, applicants and licence holders. It is guidance, so it can be departed from, but the expectation is in the main, as with all guidance, it usually is followed. The Licensing Act policy that you have today is the policy for Winchester City Council. So as you can imagine, different areas have different requirements. Our policy will be quite different to Westminster. We'd also be quite different to Bath, albeit we might be similar. The expectation is that we're setting out openly to applicants and to licence holders what we as a City Council would expect. Equally, it gives guidance, local guidance, to members of the committee when making decisions on applications. So as you'll be aware from your training earlier this year, the legislation is permissive. So unless we have representations, the licence is granted as applied for. We make no changes as officers. We have no decision-making powers apart from as our own. We can also be a responsible authority in our own right. That doesn't happen very often. So unless we have received representations and the application comes before a subcommittee, that's where the subcommittee must consider the section 182 guidance nationally and our own guidance locally. It doesn't mean to say that they can't depart from that, but if they do, they just need to make sure that the committee give good reasons. As with any decision, you must give good reasons for your decision.
If I may come back, so for hypothetical small events in Winchester, looking at the anti-terrorist aspects of these things, is it simply down to members of this committee to take a view on the appropriateness of any anti-terrorism measures that may be required?
The committee may, I have to say, I think ordinarily the likelihood is that that would be put forward as a representation by the police. I think it'd be very unlikely that you were in a situation as a committee that you would feel the need to impose a condition that hadn't already been raised as part of a wider representation. You could still do that, and as long as you've got good grounds to say, you would expect, you know, the organisers to have some form of training or implementation.
I was thinking rather the opposite way around, actually, there would surely very rarely need to be an occurrence where we would need to take a strong view on that thought.
Where you would need to.
Where we would, yes. I
Where you-
wouldn't have thought there would be many occurrences at all in Winchester for small events like that.
I think sometimes you could class as a small event. However, sometimes it's impact as opposed to the number of people. And I will sit here and say I'm not an expert on counter-terrorism.
And I
but
suppose
obviously
that's my point, that
we work with the
who would we expect to give us that guidance?
it
then?
would be the police or specialist counter-terrorism officers.
And similarly
So-
for violence against women and all those other myriad.
Potentially, yes. I think certainly and it might not necessarily always come through the licensing committee. So if the license is granted for an event, but the police had some form of intelligence that a particular event may be targeted, they would contact the event organisers, and that would be something that would be dealt with through the safety advisory group, of which licensing are members. And so, okay, it might even be something that very few parties are aware of. It might be a conversation purely by the police or counter-terrorism officers and the event organisers themselves. So I think if it's something that's going to be likely, you know, there's a target for a particular event, certainly event organisers know about it. What
would
we're
be advised, yes.
Yeah, what we're trying to do is just make sure that we try and acknowledge that this has clearly been a change that the government have wanted to review the guidance to ensure that it's considered. And so I think in view of the timing, it'd be remiss of us not to include that within our policy.
I support that.
Thank you. And Carol's explained it very well, but I would also going to make a point because there are new members on this committee. But of course, we do have safety advisory groups, and we can perhaps elaborate on some of those afterwards. But they're usually carried out with the larger and perhaps more critical events, and they take place over a period of time, and they isolate particular issues that may occur and deal with them with the appropriate authority. So it may be the police, it may be licensing, it may be road traffic, all sorts of things, but those could be raised. But the police are always looking at our licensing applications, and they are the ones often that make the case against the license being granted, as well as sometimes from members of the general public.
And I'd also take into account the terrorism threat level
The
as
current
well.
level.
Yeah, it's a general measure, I think, just to aid the security of any event should these things change.
If I can just add to that, Chair, sorry, Councillor, the police representation at a safety advisory group is not just licensing police, it's strategic operations who then look at everything from the police perspective, and depending on the type of event, they make their own decision internally about the level of which the policing get involved in that particular event, and they do their own risk assessment to decide how much they need to be involved with the event organisers.
Thank you, Councillor Preet.
Thank you, Chair. I just wanted to ask a question about drink spiking. As the father of teenage children, anecdotally, one hears a lot about that, and it's a matter of, I would say, great importance in this particular world that we find ourselves sort of thinking about. I don't know, because I'm new to this in much the same way as other people are, but is there enough weight in this set of guidance around drink spiking? Could it also sit, I noticed that it sits in public safety. Could it sit in crime and disorder, and could it sit in protection of young people as well? I don't know whether it adds any weight to the issue to give it more airspace in the recommendations.
I think for consistency, we've tried to keep it in one section, but you're right, there are certain things within the policy that would refer to all licensing objectives. It's been placed in the area that we think is probably the most prominent. Certainly drink spiking is something that we're aware of. Certainly reporting is on the increase. Whether the incidents are actually increasing is something that I think is a media, certainly something that's more in the media. That's feedback from local police licensing, is that at the moment it seems to be that there's more of a trend and an increase on reporting, but their statistics so far doesn't necessarily mean that there is an increase in the incidents. It's just that it's become much more of a national.
I think, Carol, you mean reducing, not improving. The events are reducing, not improving. I'm not quite sure how a terrorist event can be improved.
Sorry, have I said something out of context?
No, it was in context, but I think it was not quite, it came out not quite the way I think you intended. You're talking about terrorist events or reducing, not, but you said improving.
No, drink spiking, Chair,
Yeah.
Councillor.
Yeah. I think you meant reducing, but you said improving. I mean, don't worry about it.
Sorry, it's been a long day. I can't actually remember exactly the words I used. What I was trying to say is certainly it's something that we're seeing an increased reporting of. The police are yet to determine whether they actually think there has been an increase of incidents, or whether because there's been much more of a national media presence about drink spiking, that it's just become more prevalent for people to then consider reporting it to the police. Having said that, then that's something that police will investigate. How many of those reported are genuine cases?
Yeah.
I can't give you the answer to that, but that's obviously something we can try and obtain from the police if need be.
Thank you, Carol.
Could I just follow up on that? Because I'm aware that this is like a 5-year document, and I'm interested, the extent to which it is a living document. What I'm hearing anecdotally may be slightly ahead of what the police are saying to you is actually happening, and maybe the media are reporting somewhere in between. If this became a bigger issue, is there the opportunity to upweight it in the document?
Need to check the exact wording that we've added into the policy, but it's certainly something that we wanted to reference because of the nature of the fact that it is becoming more widely known, should we say, in the media. The how premises deal with that, certainly in Winchester, we're aware of most late night venues have the covers or something to be able to offer to customers, which are honestly rarely used, but they have them on offer. I think a lot of it is education, to be honest, for young people. There are certain venues in Winchester I know that if a drink's left unattended for a certain amount of time, the bar staff will move it. And as you can imagine, for some people that might cause a little bit of angst, and you know, I only went to the toilet and I've come back and you've taken my drink away and now I have to buy another one. But what the bar staff are trying to say is, yes, but in that time, what's happened to your drink? Do you know what's happened to your drink? And I think very much it's about a lot of things, but education of young people on how to look after yourself. That doesn't make it right. Please don't think that I'm sitting here saying that clearly drink spiking is wrong, but we also need to educate young people on how to try and look after themselves to try and prevent things like that happening.
Thank you.
So one more follow up. Sorry. So to that end, the wording of the section is measures on how to prevent drink spiking and a procedure on how to deal with reported incidents. I'd suggest there's a middle ground in there where I am the door staff of a club and I am concerned about a girl who is leaving that establishment, and that's not really prevention or a reported incident. It's more of a, are we training staff to have their eyes open to who that person might be getting in a car to go home with, or who might be going, it's okay, you know, we think she's been spiked, she's with me, anecdotal, you know, evidence again. But so I just wonder whether there's an opportunity to give that a little bit more strength in the way that it's written.
Certainly we could look at similar wording to where we've had before about training, bar staff training. For some premises that might be part of their process anyway. It might be something that certainly where the bigger chains have that as part of their training for staff, but we can certainly add something in if you members would like to emphasise that, as you say, to bridge that gap of some form of training for store staff and staff at the premises for awareness. And that specifically drink spiking, but I think generally there should be an expectation on all staff on awareness of vulnerability anyway.
Thank you.
Chair, I just wanted to pick up on the point on the drink spiking. Further in the document, under bottle bans, I think it was, there's a section that says bottle bans may cause an issue in as much as some women believe that a bottle is a safer option to prevent that. But it's sort of almost left in there as a non sequitur, which again speaks to, I think, what Councillor Prest is suggesting about some of this being almost floated and, you know, mention made, but leaving the, I suppose, the licensee at the kind of, you know, with a certain amount of discretion. And I suppose if you've got a situation where you're saying, okay, we're imposing a bottle ban, maybe it would be better to strengthen that to say, in such cases, could policy on drink spiking be looked at and education and things like covers be suggested? Would that be a sensible area to amend?
Read that paragraph again. I think certainly it will depend on certain premises. The expectation from the police, certainly without standardising too much, but they kind of have their own internal trigger, I guess, of a particular premises that might have a late, you know, expecting to have a late licence, or the number of people on the venue that they may require a blanket ban on glass anyway. Again, as I say, it depends on the type of premises, but I don't think that yeah, I think what it's saying there about balancing the need of trying to not have an excess of glass within a venue that those themselves could be used as weapons. but equally understanding that, like it says there, that women in particular might consider that there are safer options. I think if members would like to add something in there about having additional measures where glass has been banned, it's difficult to word, I guess, because things might change. Again, things might change in the coming years of having a really good thing that all business venues say, yeah, that's a great, I mean, they've got the toppers at the moment. I don't know what they could invent, but certainly they have the glass toppers at the moment. And if members would like to go into more detail to add reference to that, I don't see an issue. Ultimately, this is guidance and policy for members and applicants. So it will still need to be relevant to the premises. It will still need to be a reason why we're implementing anything like that, or based on representations from the police. So this is not to say that if we put it in our policy, it's a blanket condition for every premises that they'd have to do that. It's saying that we're considering and we're trying to balance the need for public safety all round.
I think it's fair to say though that you would put that in a condition if you thought it was necessary to tighten it up for that particular licence.
What I would foresee is, were we in a situation where the police, unlikely the police, reviewed a premises licence because there was a number of drink spiking incidents that would cause them concern, then clearly the members could think about having much stricter conditions in relation to drink spiking should they wish to allow the licence to continue and not revoke the licence, and that would be appropriate. And you can still do that even if it's not referred to in the policy. It's obviously good to have that as a guide and set it out as part of your reasons. But again, it just needs to make sure that it's appropriate to the premises and the application or review that you have in front of you.
Thank you, Carol. Councillor Priest.
Sorry, I omitted to ask if you could please amend that section B3 to look at having a part of it talking about training and awareness of staff around drink spiking. So that's B3, the last sentence.
Clarify the page number for me.
I'm on page 44. Of the pack, page 27 of the original B3, but there's actually, funnily enough, counter-terrorism has B1 and 2 underneath it as well. Okay.
So it's got consideration of national safety campaigns, which is Ask for Angela, which as members will know, is if any woman or any person actually feels at risk, they can just ask for Angela at the bar and people understand what that means, and that's the result of training. But you're asking about the measures how to prevent drink spiking and the procedure how to deal with forced incidents. Would you like to see training in that as well?
Yes, please.
Could it say measures including training?
Sorry, I'm trying to think of how we can word that as it's still one paragraph.
Measures on how to prevent drink spiking, train staff in awareness of spiking incidents, and a procedure on how to deal with reported incidents. Perhaps.
So I realise I can't amend the report pack, which is why I've had to move it to try and type in. So I think measures on how to prevent drink spiking, staff awareness.
Training staff in awareness of drink spiking.
It's going to help Carol if she was, if you wanted a bit more time, that we could always delegate the exact wording of the amendment to yourself in consultation with the chair after the meeting, if that would help.
I think we're here and it's not a particular onerous condition. I'd probably prefer members to agree tonight if that's okay, rather than have any changes. So training staff, to be absolutely clear, would you like to have in brackets including door staff?
I think that would be a good clarification.
Councillor Pearson.
Sorry, Chair, I nearly missed that. I can understand where the council is concerned. I mean, I've brought up more than a few teenagers, and indeed I was a teacher of teenagers for 40 years. Believe you me, spiking of drinks is only one small element of drugs. And if you're just talking about spiking of drinks, that's a relatively new incident, 10, 15 years maybe. But if we're talking about the big events, which I think Carol is trying to include in this, we're also talking about things like ecstasy and all the other pills that are peddled to kids at the big events. And indeed, I've got to say, at pubs. I remember asking my daughter, who's now close on 60, when she was a teenager, so some time ago, have you ever been offered drugs? At that time, I'd never been, indeed, still have never been offered any drugs in my life, except alcohol, I must admit. And she said, Dad, every time I go out to a pub, somebody offers me drugs. Now, this is what Carol is trying to cover in this list of things. It's not just the spiking of drinks. That is important. I'm not trying to downgrade that. What I'm trying to say is we're trying to cover a whole range of things at different events as well as in pubs themselves. And really, I think we've got to bear in mind, you're clearly a parent, as am I, we've got to make sure that our children are made aware. We have to make sure aware of this. Just written down like this are not going to impact on teenage kids, believe you me, because they're not going to read it. And they're not interested even if they could read it. So, you know, take off the pressure of Carol. I think what she's got here is a pretty good list of possibilities, but no way you can have a list that's going to cover every eventuality of drug passage and taking. Am I correct in that?
Sorry, I just realised I hadn't turned my microphone off.
Well, I was trying to say, Carol, there's a great deal more to drugs than just spiking drinks.
This paragraph that's been added is to refer to drink spiking as it's being reported. We're not going into any detail about what it's being spiked with. What we're saying is we're acknowledging that drink spiking is something that is being more heavily reported. People are more aware of it. And what we're asking is for applicants to be much more aware when they're submitting their applications on what we expect from them as applicants and licence holders, and the tools available to members should they see fit to implement it as part of a review process. What I think this does is it's generic enough that it would cover all types of premises. So it doesn't matter whether it's your local pub and nightclub in Winchester or Boomtown. It's referring to training of staff and door staff. We've obviously just had Boomtown. I'm aware of the information, and we've dealt with the setup of bars, the link with security. You know, that's quite different to how it works in a pub, but the rewording of that paragraph would still refer to any events as well as a local pub, because it is still generic enough that it covers all different types of premises.
I think I would agree with that. At the end of the day, it's up to parents to train their children to be damn careful. It's not up to us. Well, all we can do is point out to the bartenders and whoever is serving drinks to keep an eye on people picking up drinks at the bar and then taking them away from there to members, perhaps of a different sex, trying to be very woke here, and offering those drinks. And therein lies the problem. The lesson I always took to my teenagers that I taught and have looked after and raised is always make sure you see that drink from the bartender to the table. Indeed, best buy the drink yourself so you can keep an eye on what is happening to it. That's the lesson. It's not what Carol or Fiona might write or what we put in this. I'm not saying you shouldn't. What I'm saying is I think we've got enough there to move forward.
Thank you, Councillor Pearson. Councillor Aiken-Smith.
Thank you, Chair. I think the fundamental difference is the fact that with spiking of drinks, people don't know that it's happened. Whereas if they're taking drugs, then generally they are the ones that are taking it, so they know that they've taken it. So I think it is important that there is a distinction in the policy. Thank you.
That's a press.
Just wholeheartedly agree with what Councillor Langford Smith has just said. Spiking is a particularly pernicious offence committed by one person upon another. And as the father of teenage kids, I know that teenage kids will do all sorts of things to themselves when not supervised fully. But I think someone who takes advantage of someone in that way, I think it deserves to be called out. And I think we should remain increasingly vigilant on it as a subject going forwards.
Yes, and I think that training the door staff is a very important part of that as well. So thank you for that. We move on to the next part. Right, Appendix B. Any on page 54? Any comments? 55, 56. Sorry, Councillor Langford Smith.
Thank you, Chair. With regards to page 55, paragraph 2, plastic containers, I'm somewhat uncomfortable that as a council we're requiring people to use plastic. There are plastic alternatives available. Can we look potentially at the wording of using a plastic alternative as opposed to using or requiring use of plastic cups? Thank you.
Carol.
Absolutely, Chair. Trying to think of an alternative word to use. Certainly, I'm sure members understand why there's the need for that, but I completely appreciate that the time that we're in, plastic is probably not the best recommendation.
I think the problem you've got is if you just put recycling in, that includes glass at that point.
Perhaps starch-based?
Or whether we simply say non-glass based.
Yes, I think it's probably the best alternative.
So it's clear that it's not glass, but
We'll make
we're
it
not
recyclable, non-glass
exactly the
recyclable.
type.
Yeah.
Non-glass based alternative.
You could
That's
put,
all.
could say in brackets, e.g. A couple of examples, such as the starch-based ones or something. So good point.
Just to clarify, members happy to reword that paragraph instead of plastic to say non-glass containers. That says and Tuffley's glass.
Yeah, okay. Moving on then to page 55, 56, 57. Yes, that's right.
I'm looking for some clarification here. I do understand the prescriptive statements are being deleted and they're being replaced by guidelines. We have been talking about the guidelines throughout this evening. I do understand officers are very conversant with the guidelines, but if the application comes to the committee to decide on a particular license application, I think the councillors perhaps would need a training on those issues in terms of guidelines. What are those guidelines? Because we are lay people, we wouldn't know exactly what guidelines are applicable. So I don't know whether you have any plans to do that for the councillors particularly. I don't dispute what you're doing over here, but I was thinking about the councillors who would be passing and making a decision.
So there's an annual training session for all new members and a refresher once you're elected. What I would suggest that if there's a particular case that's being brought before you and you have questions or you'd like guidance from officers in advance of the hearing, then you can ask for that. What we may say back is that if there's a particular question, so sometimes members come to us with questions regarding the application, we'd go through that and then I'd ask that member to raise that question in the public forum so that then it's something that we have the discussion in public. It's not just a question that we've dealt with behind the scenes where members of the public aren't necessarily aware of what we've had a discussion. What I would say is that in terms of rotation, my understanding, and Nancy can correct me if I'm wrong, is what Democratic Services try and do is where there are new members on the panel, you'd have a experienced chair or at least other experienced officers, members, sorry. That might not always be possible, but certainly if we're in a situation where members are requiring additional support on a particular topic or premises, then officers are here for you to ask for assistance before the meeting.
Okay. Right, carrying on. Page 57, 58, 9, 60, 61, 62, 63, 64, 65, Appendix D. There's no changes in that until page 72. We've got any queries? Councillor Wallace.
Yeah, right, thank you. Thank you, Chair. On the temporary event notice,
Which page are you on first?
72.
Okay, yep.
It's under the description at the start, it says that you have removed reference to the limitations as they have been changed and could be amended again in the future. But there's doesn't appear to be any reference to those or any other limitations in this document, either on that page or on the earlier one where I missed it, where I wasn't quick enough.
The limitations are set out by regulations and by the legislation. So when the Licensing Act was introduced, there are certain restrictions on the number of events per premises, per person, and the length of time that the event can go ahead for. An example is during COVID, the government changed that and extended it. They could revert back. They may extend it in the future. What we wanted to do again is try and future-proof. So it would be as prescribed by the legislation at the time that the event is submitted. So officers check that upon receipt of the temporary event notice. We check it in line with whatever the current restrictions are for temporary event notices.
Right, so that's covered in kind of a national legislation almost, and this is just a local. Okay, thank you.
Thank you. That was the question I was going to ask. Councillor Langford Smith.
Thank you. I'm possibly duplicating the question here, but on page 33 at 311, the criteria includes an audience capacity not exceeding 499 people attending, and that's been removed. But then on page 72, it states the 499 people again. Yes, originally on page 33 at 311, under the temporary event notices, the exceeding 499 people is crossed out, but then it's back in on page 72.
Yes, I see. Thank you, Councillor. We can take that reference to the number of people out. I think the idea there that because that hadn't changed at any point, the temporary event notice process has always been for no more than 499 people. We left it there because we're not aware that that is ever likely to change, or certainly less likely to change than the other restrictions that have been amended along the line. For consistency, if members would rather that was removed as well, we just refer to whatever the current current legislation or regulations are, then that's fine.
Thank you.
Okay, that's right. Well,
I understand you have taken out the duration, how many days that the temporary event notice should last. I would have thought there must be some upper limit for the duration of the TEN. Why there's no mention of number of days the event can last or should last? 1 day, 10 days, 5 days?
Again, that's something that's prescribed in the regulations or by the government. So we would review and validate the temporary event notice based on whatever the current legislation and limits were imposed by the government. In case that changes is why we've removed that. That doesn't mean to say that we're allowing an event without a deadline. What we're saying is that officers will review it in line with whatever the current legislation is at the time.
My really problem is, if suppose I was to organize a small music event for an evening, this is a TN, correct? I'm not a proper licensee. If I were to fill in the forms as an ordinary member of the public, what kind of advice Winchester will give us on this particular case?
So temporary event notices
Yeah.
are a tacit consent. The applicant can apply as long as it's within the restrictions set out by the government at the time,
Okay.
and they provide us with the relevant number of days notice for it to be either a standard or a late temporary event notice. If all of those boxes effectively are ticked and the notice is sent to the police and environmental health for their consideration, if they do not object, the notice goes ahead. So there's only changes if the police or environmental health object, in which case if it was a standard notice, that would come before a licensing subcommittee. If they objected to a late notice, the event doesn't go ahead.
Understood.
So the temporary event notices have lots of restrictions, and that's something that the officers have to check at the point that we receive them. It's then ultimately down to the police or environmental health to stop that from going ahead if they had concerns. We can only reject them if it doesn't meet what the regulations set out, or if they've not given enough notice.
Thank you.
Councillor Paul.
For Councillor Ashwell's reassurance, the application form has a series of criteria with it, which you're encouraged to read at the same time, which is so it's a bit like filling in a driving licence. You know what you're going to be filling in. So it's made very clear at that point of what the current situation is.
Thank you. Moving on to the equality impact assessment. Does anybody have any questions on that? No. Anybody got any further questions?
Thank you, Chair. This one, sorry to rewind everyone further back in the document when we were making such good progress. On page 25, I think it was section 2.15, it says that the strategy is to support cultural events and live music. The wider context in the UK is that live music venues have been closing at an alarming rate, to the point where the nighttime economy and the kind of performing arts is becoming increasingly unsustainable. That's obviously a laudable aim that we're setting out there, that we want to support that. But I notice there's a potential conflict on page 27, section 2.24, which says, in accordance with government guidance, the licensing policy makes it clear that in areas of denser residential accommodation, stricter conditions relating to noise control will be imposed. Now, I guess the question I have there is, if you were, say, redeveloping central Winchester and you increase the density of residential areas around a venue which already had a license for performance and music, and then the new residents subsequently said, oh, I don't really like the fact that I'm being kept up at night, you would be creating a condition where, because you're saying noise control will be imposed, you're immediately putting the bias against the pre-existing venue with the performance space. Is there any way of kind of mitigating that unintended consequence, or is that a possibility that wouldn't happen?
It could quite likely happen. We have other premises, certainly there's a particularly in rural areas where nice quiet country pub, been the same landlord for 10 years, and then that changes, somebody else comes in, they need to find other ways of trying to make more money because it's very expensive to try and run a pub. They bring in someone, live music, the neighbours have never had to endure that, shall we say, and that makes it very difficult. What the environmental health or environmental protection officers are there to do is then to try and balance that. And that's why, as part of the last policy review 5 years ago, the noise reference in this policy was quite significantly changed and amended, because it is always a balance. It's understanding that that venue has been there a long time, they are there to run a business, but equally people have the right to enjoy their home. And I think this is where sometimes it quite often gets flagged with planning, is that you know, planning and licensing are separate regimes, but that's something that planning should consider at the time of when they're considering where to put in residential properties. Because once they've got the planning, they then need to consider licensing is separate. But what we find sometimes is that people try and use the licensing regime to try and stop something that's already been given permission. And so it's about acceptability and trying to keep that balance, which, as I said, is the environmental health officer's view, and for them to consider as part of a license application. But also, if further down the line, you know, there is a premises that's causing unacceptable noise to residential properties, that's something that they would look into. Just to add that the environmental protection officers that deal with licensing are usually the same officers that deal with planning applications, and what they try and do is try and give some form of guidance as part of their planning comments, I guess is the right word, so that, you know, nowadays there's lots of different ways of being able to soundproof buildings, and this is what's being used in a lot of areas. I don't know so much about Winchester, but if you have a licensed venue that's been there for 50 years and then you want to build a block of flats next door, it's then being able to say as part of the planning process, well, there's a pub here, you're going to need to build these premises to make sure that you're providing sufficient soundproofing because there is this venue here, and not, you know, not build these flats and then leave it up to them to be concerned about the premises that's been there for so long. So I haven't really answered your question because it is a balance, but hopefully that gives a bit of an understanding on how the regimes work.
Well, thank you. Actually, that's very helpful, because I guess the question was about unintended consequences of how prescriptive that section of that word will would be, rather than may be imposed. Noise controls will be imposed suggests that, you know, there's always going to be the presumption that, you know, a control will be imposed on a licensed venue. But it sounds like there's a certain amount of discretion that will come in at the planning stage, which should mitigate that. Thank you.
Yes, and just to add, environmental protection, when they review applications for licenses which involve live music or recorded music, they have their own kind of guidelines. So most of the time, and I think we refer to that in our policy, that 2300 tends to be a time that they would expect either a reduction in noise or that balance of being able to provide entertainment during the day. But there's an expectation of after a certain time that volumes turn down or additional conditions are there to try and mitigate any nuisance.
Certainly, in my experience, it's worked as a balancing act on both directions. I'm quite confident on that. Councillor Morris.
To pick up on Councillor Brophy's point, bearing in mind that it is, as you say, in the balance and open to us making the decisions and revising stuff, is a case that the wording could be changed from will be imposed to may be imposed, because at the moment it does seem to predetermine the outcome.
I think what might be useful, if I find the relevant page in our policy that goes into more detail about noise prevention and nuisance, if that will help members while we're here. Just need to double check what page that's on. The noise controls is specifically referenced on page 46. And this is the section that was overhauled effectively as part of the last review. And certainly there's obviously reference to the South Downs National Park and the duties that members must have regard to as part of the licensing process if you have an application before you. I think the current wording, I think, is clear to applicants that there is a higher expectation for them to do more in an area where there's a lot more residential properties and people who could be affected by the entertainment that they're providing. And so by saying will makes that clear that that's what the expectation of Winchester City Council is that if you're going to provide entertainment in an area where there are a high density of properties, the expectation is you will have to do more to try and reduce the noise and nuisance that residents could be affected by.
So it exists there as quite a strong deterrent, but we still have the right to ignore that or go against that in a decision later on. It's not binding our decisions.
I think what it does is that if an applicant submits an application where they're requiring or would like to apply for entertainment till, I don't know, say 2-3 o'clock in the morning, they're next to a block of residential flats, as an example, where there's lots of obviously residents that are nearby, and they've made no reference in their application operating schedule about how they're going to mitigate to be able to provide the entertainment but not create a noise nuisance, which is ultimately a licensing objective of this. There's 4 licensing objectives, one of which is the prevention of public nuisance. And they have a duty as part of their application process to acknowledge of their surroundings and how, by providing that entertainment, how they could affect people and what mitigation they will put in place to try and prevent that nuisance. So if they submit an application without that, this policy makes it clear that the likelihood is environmental protection and probably residents will object, and then they'll be for a subcommittee. And what this does is says you will, or very likely, you'll be required to provide in measures to make sure that you don't negatively impact on those residents at unacceptable occasions.
But it doesn't it doesn't mean that we can't, as in the situation that Councillor Murphy outlined, we still have the final decision on this. It's not actually binding our decision.
No, the policy there is a guide for the members when they're making their decisions. You can depart from the policy, but with all decisions, you must give good reasons. So if there is mitigating circumstances as part of the application process, that you feel that on that particular application, you don't need to be as strict, and these are your reasons for that. As long as the members are happy that they've made a sound decision and it's appropriate in the context of that application, and if we were challenged, we support that in an appeal process, then that's ultimately what we need to do. This legislation is a balancing act. It's a permissible piece of legislation, so it's much easier to get licenses, but it's also much easier for residents to be involved, to make contact with local authorities if there are issues. There's a review process which anybody can trigger to review a premises licence. There just needs to be sufficient evidence to prompt that hearing. So there's much more involvement on the public to be involved in this, not that necessarily everyone's aware of that until they get an application on their doorstep.
Okay, I understand that the will doesn't mean always, which is a different meaning. Thank you very much.
Thank you. Have we any other comments on this report? If not, can we move to the recommendations that we accept this report? Yeah. Sorry, Judge Atwell.
Thank you. Thank you. In page 78, 10A. I agree with your answer. Yes, but my really concern is why we are saying the policy has no adverse impact. I think it has no impact at all whatsoever. Is there any reason why we chose to say adverse impact?
Yes, so the impact, equality impact assessment is something that's produced by officers in line with a review of policy, and this is reviewed by internally by specialist officers who deal with these assessments, because this is not my expertise. Certainly, when I spoke to her and asked about effectively the court position on how we respond to certain things, there's a template, as it were, on how we complete these equality assessments so that there's a bit of consistency for people who read these regularly. The wording of that is that it's more in line with how the wording of the Equality Act is written. And so what it's saying is that the council's considered direct and indirect discrimination, even if it is unintended. And what they say is that this is part of our requirement to show due regard to equality issues under the Equality Act and public sector equality duty, and it mirrors the language of the Equality Act to help us demonstrate our commitment. So that, by specifying adverse, helps to distinguish between the positive and negative impacts that are identified by the impact assessment process. So that was a question that I asked, because I'm aware it's a word that people don't particularly like that being part of that. And it, as I say, I'm guided as to a corporate position on certain things on how we answer that. So it's not saying that, it's trying to keep it in line with the wording that's used as part of the legislation, is a summary of how I'm told.
Yeah, I just wanted to be positive, that there's absolutely no impact, rather than, because adverse leaves a kind of a doubt in somebody's mind. Okay, is there impact then somewhere? So that's the reason, because that appears on several cases. That's why I was wondering whether we can lose that word adverse, but if that's what the guidelines are. Thank
Councillor
you.
Bolger.
Thank you. Councillor Ashford and Councillor Murphy raised this with me earlier, and I took it to Councillor Becker, who can't be here tonight, so I'm sending her apologies as well. But she said that this is something she would like to look at, but I know that Stephanie has actually looked at this today specifically, and perhaps it's something we can explore on a general matter for the council in the future. But it seems that at the moment the advice is that it reflects the Equalities Act. So we've taken the matter seriously, but at the moment it is as it is. But Councillor Becker will take a special look at this.
Thank you.
Pearson.
Yes, I would like to thank Carol for the work she's clearly put into this document. I've watched various iterations since I was portfolio for this back in 2006, 2007. I think Carol was, you just joined us at that time, were you not? Pretty well, yes. But I mean, I've been fighting against drugs as a teacher since the 1960s, 1970s. Believe you me, the drug of choice has changed so much in so many ways. It's very, very difficult to keep track of it. And I think this is reflected in this paper, Carol. Thank you for it. The same applies with counter-terrorism. A bit surprised it's been so long coming into this paper, but it's a welcome introduction. Again, I've been aware of counter-terrorism since the 1980s. When I used to get phone calls from time to time, Dad, will you start checking under your car in case there's a bomb there? Now, that's not the sort of phone call you like to hear, but it's one that I received, I won't say very regularly, but from regularly enough to make me a little bit nervous, especially when you're parked in a school car park, trying to explain to people why you're constantly looking into your car, trying to work out why there's something wrong with the exhaust pipe. Because I think if I'd said what I actually was doing, I'd have been asked to take a leave from the school for safety. But again, because of the procedure I had to, I used to go to many army bases at that time. I won't go into the detail why, but the things, all of this is reflected now in this paper, bringing it up to date as you possibly can. First terrorist event that I'm aware of in Winchester was, I think, was in 2013, when I was at an event in the university with Dr. Abdullah Abdullah, who was then the Afghan Prime Minister. And we had two security guys came in with the radios, dark suited, typical thing you read about. You think you're never going to see them. And they spoke to myself, then the ambassador for Afghanistan was sat beside me, and then to Dr. Abdullah, at which point all the Afghans got to their feet and left, taking the chancellor of the university with them. She had no idea why she was being taken out. And we were left there at this dinner, wondering what had happened. Until later, we found out that actually it was an exploded shell in the River Itchen, which had been left after wartime events. It wasn't actually a terrorist event, but that was a close that. Other than the phone calls, as I say, that's get from time to time. But this is reflected in this paper. It reflects the respect agenda, which I've been aware of for quite some time. But I would say to all parents, the first line of defense for your children with drugs is what you say to them and make them aware of what their behaviour might lead to. It's not up to Carol, it's not up to Fiona, it's not up to us as a licensing committee, it's parents. They are the first line of defence, whether we like to admit it or not, we are. Unless we warn our children, and it's very difficult when you're speaking to children who are 17, 18, 19, who know it all, you can't tell them anything. Very difficult. But that's the first line of defence. All we can do is try to block as many avenues as we can, bearing in mind the drug of choice from straight from marijuana in my 1970s, I think it was, to the wicked stuff that's being sold now. Marijuana in those days and what it is now, it's just, I can't believe the difference. But thanks again, Carol. Good paper. Well,
Thank you, Councillor Fulfer. Councillor Pitney. Yeah, would you like to sum up the changes?
Yes, Chair, I thought it would be useful I summarise the changes. If I've missed any, do let me know. So the first change I picked up was on page 34 at 3.15, which was the change from his, her to their. The biggest change is probably on page 44 in relation to the drink spiking change, which I've written down as measures on how to prevent drink spiking by training staff, including door staff, in awareness of drink spiking and a procedure on how to deal with reported incidents. There's a change on page 55 to remove the reference to plastic and replace it with non-glass based alternatives. And there's a change on page 72 to remove the reference to 499 people in the temporary event notice section. As I said, that's all I've got written down. So if I've missed anything, I'm sure somebody will let me know.
That mirrors my list, Fiona. Thank you.
Okay, thanks.
Right, thank you. So the recommendation is to approve this favour with the amendments as attached. Is everybody in agreement on that? Yeah, Councillor Fulfer.
I just thank Mrs. Devendrick and the team for the work they've been doing, but also you for your challenging questions. I think it's good that we do scrutinise this well before it goes out to consultation. So thank you too.
Yes, I'd like to add my thanks to Carol and her team because this has been a very good report. You put a lot of time and effort into it, which is appreciated by us all. Thank you. So shall we move on to the renewal of the alcohol consumption public space protection order?
Hello, thank you, Chair. So my name is Davina Damone Hollands. I'm a Neighbourhood Services Officer, Winchester City Council, and the Anti-Social Behaviour Lead. So the Public Space Protection Order provides discretionary powers under the Anti-Social Behaviour Crime and Policing Act 2014, Section 59, to deal with nuisances or problems which harm the local community's quality of life. The Public Space Protection Order is intended to ensure that people can use and enjoy public spaces safe from antisocial behaviour. Home Office guidance sets out the Public Space Protection Order should not be used as a target for someone who is homeless or rough sleeping. Breaking an order is a criminal offence which can result in a fixed penalty notice or prosecution. If prosecuted, an individual could be fined up to £1,000. And only those over 18 and over can be issued with a fixed penalty notice, which is £100. The current Public Space Protection Order is named as the Alcohol Control Zone. A lot of people think it's an exclusion zone. It isn't. It provides Hampshire police officers with the powers aimed at tackling street drinking and antisocial behaviour. Due to the current size of the alcohol control zone, we have consulted with those in the larger public spaces, such as the Winchester Diocese, Winchester University and the Natural Environment team at Winchester City Council. So the police do use other powers of alcohol-related ASB, public order offences, but they don't use this in silo. The PSPO provides an opportunity for early intervention. So the current PSPO order expires on the 14th of September at midnight. And so we are looking to vote it through, please, for a further 3 years. So happy to take any questions.
Yeah. Very good. Have we got any general questions, or do you want to go through it like page by page? Right.
Plenty of comments about it because I was at the portfolio that introduced this. I would simply say, believe you me, the time we introduced this, we had a problem here in Winchester. We had people in the high streets drinking out of brown bagged bottles. We had groups of them in Abbey Gardens, and it was a major concern. And what we tried to do, which Carol will remember, I'm not sure whether you were with us at that time, Davina, were you? I think you came later.
I'm probably too young. It's not.
Thanks. I think everyone's too young. Probably get to my age to remember too much and forget too much. But we did have a problem. Our concern then, and I suspect probably still is, and Davina will be able to correct me if I'm wrong, we're concerned if we introduce this exclusion zone, and it wasn't to get rid of alcohol in the town centre, that was not the intention. It was to give the police, as Davina quite rightly said, the authority to tap people on the shoulder, will you move on, please, and confiscate the alcohol that they were drinking and often abusing. That was the reason for it, and in that it's been highly successful. But what was at that time, and I suspect is still happening, what we did is push many of these people out of the town centre to the periphery. Hyde, for example, was one of the areas, the care home in Hyde, which had lots of problems at that time. Do they still?
I can confirm at the moment that no, it doesn't. Evidence doesn't suggest that at all.
They also went up to Bushville Camp, which was another site. A lot of them went up to, and had real drinks parties up there. That there wasn't as much vegetation then. Of course, we're talking about 2007, and it's changed quite a lot up there. But it's been, I think, one of the most effective tools we've given the police. And I believe certainly for Signal Police, they've been incredibly grateful. And I know it's a weapon that you people appreciate it. And indeed, my local AXO appreciates as well, because it also gives him the authority to tap people on the shoulder if they're drinking in a recreation ground in the local skateboard park. Look, there's an exclusion zone. You don't overdrink. And to confiscate the alcohol. That was what we wanted to do, and that's what it succeeded in so doing. So thank you for the paper.
You're very welcome. Sorry, Councillor Pearson. Sorry, it's not an exclusion zone. Just that it's a control zone. So
that's right.
Yeah.
Well, it would have stopped out all the sidewalk drinkers. You never want a cafe. People probably say, well, you can't drink here. Move on. Well, of course, it wouldn't have worked. We anticipated at that time that would be an eventuality. We wanted that to happen. It was the itinerants, regretfully the homeless people who occupied the time by drinking 23s, I suppose, in the cold nights. And that, I think, was very effective, but it pushed it out to the side. And that's still, we thought at that time, should we include the whole of the urban area? Yeah. But we were asked not to, I think. I'm not sure whether that was wise in retrospect.
Thank you, Councillor Pearson. Councillor Ackworth.
Sorry.
That's all right. We were expecting a Pearson moment for us.
Thank you, Chair. I'm new to all of this, so I've not seen any of this before. I'd just like to say I was very surprised at the extent of the consultation, the number of people, how wide it is. And I think from the statistics, it's very clear that it's working. So I think it's a very good thing.
Yeah, we do actually have some stats actually that just came in today, hot off the press, so to speak. The police don't currently record requests to stop drinking, but they have recorded confiscation of alcohol within the reporting period, which was 2020, up to the current date, and it shows that the powers were used 13 times, but those were recorded. There are a lot of other tools and powers that the police would use, such as community protection warnings, community CPNs, community protection notices, criminal behaviour orders, etc.
Thank you, Councillor Byfield.
Thank you. Actually, I think you anticipated my question, which is really, I think it's an excellent report and, very, very comprehensive. But one of the things I was looking for was beyond the anecdotal accounts of which consulted parties found this valuable, to actually see the evidence of the amount of, say, times it had been used. And obviously, if the concern is that the police aren't reporting the amount of times they're actually using powers given to them under this order, then we're basically using an anecdotal base in order to extend the powers of the police to police our communities. And thankfully, it doesn't sound like anyone's objecting at the moment. It sounds like it's been applied incredibly judiciously by our police forces, as we'd expect, but it does open up a risk. So I don't know if there's any way of moving forward to ask the police to start capturing some of that detail a little bit more, or if that would be an undue burden. I wouldn't want to give them more work than they have, but it might be an interesting thing to move the conversation forward, because looking at this, you could see that in the recorded event, say the instances of antisocial behaviour associated with alcohol may have reduced, but that is a correlation, doesn't actually suggest any causality with this particular intervention. So, you know, I'm all for this, but obviously moving forward to make a decision on whether it's appropriate, it'd be quite useful to know what the before and after looks like, and also what good looks like and what we're looking at moving forward in 3 years' time, perhaps when we're having this decision again, whether it would be possible for the police to start capturing a bit more of a kind of an evidence base for us to be able to point to, particularly if people had, say, civil liberties concerns. Actually, also just to touch on Councillor Pearson's comments about the policing of, say, particular communities and particular groups in the high street. I think when we spoke about Davina, I think you made a very important point, which is that this is a universally applied policy, and it's not specifically with regards to discrimination targeting any particular communities specifically, but it is actually universal. I think that's an important point to put on the record, that it's only the people who are seen to be antisocial or have been reported who would be targeted in this way. Is that correct?
Absolutely, Councillor. Yes, yeah. We have done completed a new equality impact assessment as well. You know, for instance, homeless. You know, anybody that's homeless or rough sleepers are not targeted. It's a blanket approach to everybody, quite clearly. But with regards to reporting, as discussed earlier, certainly, you know, if people would like, you know, if any of you would like any sort of further stats sort of drilled down, we could certainly put that forward to the police. But again, that takes time, you know, for them to collate that as well. And it is as good as the person putting the information in. For instance, if it's put down as a Z occurrence, how that incident is recorded.
Okay. Councillor Pett.
Thank you, Chair. This might be pedantry, but in Appendix 3, the title of the map is Alcohol Control Zone. In the legend of the map, it talks about Alcohol Exclusion Zone. Control is the correct, isn't it?
Correct. It is a control zone and not an exclusion zone.
So could we have that changed?
No, mine is correct. Sorry, could you just refer to which appendix?
Appendix 3, which is just the map.
Okay, I can confirm it is control zone.
Mine is titled control zone, but then at the bottom right it says original alcohol exclusion zone.
That yes.
Right, okay.
So that is, yeah, that is an error that I can change.
So dispersion control.
So that's a test, and you've passed. So well done. We wanted to make sure that people were reading the document. So thank you. I will. Yeah. And a lot of people, you know, years ago did know it as the alcohol exclusion zone, and it was changed to the alcohol control zone. But I will amend that. Thank you.
Shows the central area, and it just shows alcohol control zone. So this is an old map, I think. This one.
It says revised July 2007.
Yeah, I think it's a very old map. It's the long one that's up on the.
We did have some problems with the GIS mapping, but as I said, be assured that I will check that the correct map is on the website.
Can I assure you the one that's sitting here in front of Davina has got control zone,
which is hot off the press tonight.
Oh, spotted. Thank you. Councillor Morris.
Yeah, while we're actually looking at Appendix 3 in the map, I noticed that obviously the map is slightly out of date and it doesn't contain Kings Barton developments because the city limits have actually increased a little bit since this map was drawn up. And my question is whether when we agree this, we lock in the boundary of this PSPO area, or whether if residents are concerned or the police are concerned, that the boundary of this could be extended or modified in some way to take into account new residential developments such as Kings Barton.
Thank you very much, Councillor Morris, for your question. So the current alcohol control zone does go across to the motorway and actually up to Barton Farm. So we only rely on evidence that is provided by the police with regards to and it's evidence based, and the evidence that they have given us, it would not suggest that there was a problem. But what we'd have to do is you can't, it's not possible to amend it at this stage because the current PSPO expires on the 14th of September at midnight.
So when it's renewed, is that the only time we can modify it? We're in the process of drawing up a new one.
Thank you, Councillor. There would have to be a public consultation, a lengthy public consultation, and there would have to be a proven need for it, because actually the PSPO is that there's not always a need for PSPO. So you know, it's very strict guidance on if there's a requirement for a PSPO to be in that particular area, and it's all based on evidence.
Okay, I just sort of amused at the idea that Kings Barton is now the last chance saloon outside Winchester. Thank you very much.
If it reassures you, Councillor Morris, so we work very closely with all the neighbourhood police teams across the district and many other teams. I'm not saying that there aren't, you know, there aren't issues, pockets of issues here, there, and everywhere, but it certainly hasn't come to my light, to my attention. You know, as I said, I work very, very closely with all the neighbourhood police teams, and if there is an issue, you know, please do let me know and I can address that.
Thank you. Any other points?
There is another point actually, just coming from what you said. We talked about extending it to the H2 settlements. But we decided at that time it wasn't feasible. We didn't have the police force. We didn't have the neighbourhood services. And at that time, neighbourhood services did a lot of work in the parishes. It's now been taken over by PCSOs and, as far as Bishop Saltham's Home are concerned, an AXO as well. But what it does do, it doesn't cover those settlements. You could argue it should, but it doesn't. The reason it doesn't is because the mixture very often, whether it's a control zone or an exclusion zone. If it was an exclusion zone, you close every pub in the district down, because they'll be drinking alcohol in the tables outside, especially in this weather. What it does do within the city, it gives the police that weapon, not just for the itinerant. That was a misstatement on my part. Also the students coming out of the pubs at closing time, going up the high street, rocking and rolling with a bottle of beer or whatever in the hands. What happened to the bottle afterwards? If we didn't have the exclusion zone, I shudder to think. I've more than a few broken windows in the high street in the past. But it gives the police and the neighbourhood service and the PCSOs that extra authority to control that. I've got to say the university does a lot to help us. Or it did at that time. I assume it still does. The student union.
Sorry, Councillor Pearson, can you
Does
repeat?
the student union also do their policing to control the behaviour of students drinking in the town?
They do have people, you know, patrolling in the evenings. They do have security guards up there in the evening, and they will nip anything in the bins.
We needed their support as well, because a lot of the drinkers were 17, 18, 19, 20-year-olds from the university. I won't say all of them, so a lot of them are. And of course, there are others as well. For want of a better term, the civilians who are neither itinerants or students. It's that control factor. It gives that ability to say, oi, you're excessing, you're moving into antisocial behaviour. Stop it. Give me that and I'll dispose of it. What they usually do is just pour it down the nearest drain. Or they used to. I won't say you still do it. Well, of course, I mean, you do want the stuff yourself.
Thank you,
can't
Councillor
deal with it. It's been, as well. Anyway, I've said too much. Sorry, Chairman.
That's quite all right. I'll let you off this time.
Well,
Don't let
I'm
it happen
trying to
again.
find a piece of support a piece of legislation I introduced, for goodness sake.
I think it's
I
important.
can't.
Sometimes it's important to understand what happened in the past. Has anybody else got any points? So the recommendation is that the extension of the public open space protection order for a further 3 years to 14th of September 2026 to be agreed. And two, the Strategic Director of Housing Services to be authorised to carry out the statutory publication and notification requirements for the extended order. Are we agreed? Thank you. And that concludes the meeting. So I'd just like to thank the officers for all their time and 2 excellent reports. Thank you.